Hi, this is Alan Gassman, and I welcome you to this presentation entitled Creditor Protection Planning for Physicians and Medical Practices. It's Wednesday, August 12th. It's dry in Clearwater, Florida, and my partner and I, Crotty Denicolo, have put together this slideshow that you should be watching, and my assistant, Janine, is going to describe how you can get a copy of it if you did not get the email that we sent. Go ahead, Janine.
Thank you. On the GoToWebinar box that pops up on your screen, you'll see a plus sign next to the word Handouts. If you click that, it will open the Handouts section of the box, and you'll be able to click right on the PDF that says Creditor Protection Planning PowerPoint, and it will download to your computer so that you can save it or print it or watch it on while you're watching the webinar.
And if you want to view a copy of this webinar later, just let us know and we can send you a link where anyone can take a look at it for free. If you're a Florida lawyer or a CPA and you want continuing education credit, just let us know and we can provide you with educational credit. We have some upcoming webinars that you're welcome to tune into. I'm very excited about Tuesday, August 18th, a medical law update with Lester Perling. Saturday, September 12th, we're going to talk about the biggest mistakes that successful parents make with respect to college and related decisions with a really good counselor, Molly Smith. September 24th, the biggest legal mistakes business owners and investors make, how to avoid making them. The biggest mistake would be missing that one. Then there's 10 more. October 1st, income tax exit strategies with Steve Gorin, a fantastic tax lawyer. That's going to be a very interesting program for tax professionals. Saturday, October 3rd, failure to launch, what happens with 20-somethings who don't have a solid career path, again with Molly Smith. And Wednesday, October 14th, conventional and advanced planning techniques to minimize taxes and pass wealth. I'll be talking on that. So please invite anyone you like to these. They're all free. Now, creditor protection for doctors. Point 1. It was not raining when Noah built the ark. If you want to be safe or as safe as possible, please do this planning before it happens, not after it happens, and I thank Dennis Kleinfeld for telling me about that saying. Also, on the creditor protection issue, I'm going to just cover the tip of the iceberg in a lot of areas. We have more extensive creditor protection information available to you. Some of them are in our free webinars that you can view at our website. Some of them are on YouTube. If you search Gassman Protection YouTube, a lot of them come up. And then our book, Creditor Protection for Florida Physicians, is available on Amazon. And also the Practical Guide to Kickback and Self-Referral Laws is available on Amazon, both for physical books and for downloads, for Kindle downloads. We also have the Florida Physician Advertising Guide and the Florida Guide to Prescribed Controlled Substances and Pain Medicine, both written with the leadership of Lester Perling of the Broad & Cassell Law Firm. Here's a table of contents for today's presentation. And at page 8, let's not assume that all lawsuits are going to settle at policy limits. And let's not assume that $1 million, let alone $250,000, is a lot of money in this area. Anyone could picture somebody losing fingers and feet, and this one turned into a $30 million tummy tuck. So that's an actual jury award. Here's one for a stroke misdiagnosis. An unlicensed hospital worker misdiagnosed a stroke, thought it was sinusitis, $116 million awarded. Here's one where doctors who had a $217 million verdict against them are sued their lawyers, for not encouraging them to settle. They said that if they had been told to settle, they would have demanded settlement from the carrier. The carrier, I believe, had offered to settle, or would have offered to settle within policy limits. So you have to be very careful when you're in a lawsuit. If you have the opportunity to have the carrier settle within policy limits, and the carrier refuses to do that, you want to make sure that you demand that they settle when they have the chance. These doctors apparently didn't make that demand and then ended up suing the lawyers who allegedly should have told them to. Here's another one. I think a few people will remember that. May 2006, a Friday afternoon jury verdict against a doctor in Tampa who then went and hung himself. Maybe if he had done some of the things that we're talking about in this webinar, and particularly if he had perhaps read Dale Carnegie's book on how to stop living, he would still be practicing. But these things happen, and we have to take them very seriously, both as professionals and as doctors. Yes, most malpractice claims settle, but the worrying about whether yours will be the one to settle could kill you, so you want to be careful. Okay, it's not only malpractice liability, believe it or not. While most of our clients are practicing physicians, more than half of our physician creditor protection issues come up from car accidents, business transactions where doctors have guaranteed debt or get sued because of a business transaction, or poor choice of partners or people to do business with. So beyond malpractice insurance, which is what most physicians worry about the most, let's make sure that there's plenty of liability insurance. Let's make sure that no one but the physician is driving the physician's car. Let's make sure that rental properties are in limited liability companies. Let's make sure that we don't buy real estate unless we make sure it never goes into our personal name, and/or we have environmental surveys. Let's make sure we don't have employees working in moldy buildings where they could get a health problem. There's plenty of ways to get sued besides malpractice. But on the malpractice side, before I forget, I'll often talk to a group of doctors and say, how many of you, when meeting with a patient, spend 45 seconds thinking of, number one, how might I get sued for this situation? Number two, what do I need to put in the chart to prove that I warned the patient, and how do I need to warn the patient? And number three, what letter or notes am I going to send to the other physicians on the team so that if something goes wrong, I've pointed it out and it's not my fault? And a lot of doctors have thanked me for making that observation. Just remember the 45-second pause. It may not be 45 seconds. Just say to the patient, let me look at one thing here, and then just think, what could go wrong? I know we get so busy that we just don't think about what could go wrong, but most of the time it's something that if you could go back in time, you wish you had thought about. Also, the first line of defense on a lawsuit is insurance. Make sure you have plenty of it. With your car and homeowner, you typically have $250 coverage for cars, $300 coverage for the home, but if you have one of those citizens policies, you may not have $300 on the home. And then typically there's a separate policy above and beyond that called the umbrella. We do have a webinar called What Mary Poppins Didn't Know About Umbrellas that you're welcome to watch, but you want to make sure that you as the client or you as the advisor are reminding people about the umbrella. And if you have property up north or a car up north and the umbrella carrier doesn't know about it, it's not going to be covered under the umbrella. Sometimes you need a Florida umbrella and a North Carolina or other state umbrella. So let's not forget the importance of that. I have a letter about the umbrella policy. Then I have a letter that you can fill out and send to your insurance carrier. Make sure they know about your boat. Make sure they know about your four-wheelers. Make sure they know about your mom's house that you own. These are all things that if they don't know about, you're not insured for. Page 19, I would prefer for you to have more insurance as opposed to less. And sometimes it's not that important. Sometimes it's not that much more expensive. Like these are some 2014 competitive rates outside of Dade County. Thank heaven we're not in Dade County, although I'd be a lot busier as an asset protection lawyer if I was there. Internal medicine may pay $8,500 for a $250, $750 policy, $13,000 for $1 million, $3 million. That's 4 times as much coverage, or only 40% more. Dermatology, $4,000 versus $5,500. So it's not a crime to carry more than $250 coverage, and although it is somewhat more likely that a carrier will settle or that a plaintiff lawyer will settle at a smaller amount faster, believe me, you lose a lot of sleep in the meantime if it's a claim that clearly can be worth more than $250 at a jury trial and you only have $250 coverage. It's much more likely to settle for the limits of liability if you have higher limits. You don't have to buy a higher limit on your individual coverage. You could buy a separate limit on your corporation. So think about that. If you have nurse practitioners or physician assistants who you work with, they can also buy malpractice insurance at very high limits sometimes, relatively inexpensively. And then if you have a challenging case, always have them involved with the case so that they would be sued with you. Isn't that sweet of you? And their higher limits would also help alleviate the situation. Now, to get into some of the meat and potatoes of asset protection, we want to know some of the definitions, and you know most of them. You know a plaintiff is who's getting sued. The plaintiff is who sues you. The defendant is who's being sued. An exempt asset is an asset that under Florida law cannot be taken by a creditor as long as you owned it before you got sued. And it's very important for you to know what the exempt assets are and how to have exempt assets. Non-exempt assets are assets that are not protected from creditor claims. And a fraudulent transfer is not fraud. It's a fancy name given to a transfer that you might make once you know there's a potential lawsuit to transfer assets from non-exempt status to exempt status. And if you do that, the creditor typically has until the later of 4 years after your transfer or 1 year after the creditor knew or should have known about your transfer to try to set it aside. In some states, it is a criminal offense to commit certain fraudulent transfers. With the IRS, it's a criminal offense to try to avoid paying the IRS by making a fraudulent transfer. But in most cases, for Floridians, it is not against the law, and quite often it is the appropriate thing to do. If you have an asset that's exposed and you might be sued or you're being sued, but you have insurance, you want to talk to somebody who has a lot of understanding of the fraudulent transfer rules. And anyone who says, oh, don't ever make a fraudulent transfer is probably not giving you the right advice. A charging order here on page 21 is an order by the court where there's a judgment against the owner of an LLC or a limited partnership interest. The creditor cannot reach in and take control of the LLC. They cannot reach in or take control of the limited partnership if there are multiple owners. The creditor has to wait for a distribution to get paid. And usually creditors will settle for nickels on the dollar when they realize that all they're going to get is a charging order against a limited partnership or an LLC. So that's why multiple membership of properly drafted limited partnership and properly drafted LLC documents is absolutely essential. A secured interest is like a mortgage. I could borrow $100,000 from you and give you a secured interest in my furniture and my equipment and my personal items. And then if somebody sues me and gets a judgment, you're in charge. You can take those assets in lieu of what I owe you if everything's at arm's length, so my new creditor can't. So in a lot of situations, we want to have what we call a friendly secured creditor. And that works differently in a lot of different ways, but you want to know about it. Bad faith on page 22 is the obligation of an insurance company to settle a claim within policy limits when they have the opportunity to do so. If they have that opportunity, if you demand that they settle and they fail to, then you have a bad faith claim against them for any excess verdict. I have never seen a doctor with a bad faith claim pay an excess verdict. An excess verdict is a verdict that exceeds your policy limits. So when you have a lawsuit against you, it's a great idea to have an independent lawyer, talk to your defense lawyer, possibly talk to the plaintiff lawyer, get an offer within policy limits by the plaintiff lawyer, make a demand that the carrier will settle within policy limits, and you may be out of harm's way. But that plaintiff lawyer will often not be willing to offer to settle within policy limits unless they know that you are not exposed, that you don't have any significant exposed assets. And that's why it's very important to have the creditor protection done earlier rather than later. And there's that book I always recommend at page 23, How to Stop Worrying and Start Living by Dale Carnegie. Definitely one of the best books ever written in the English language. If you haven't read it, you want to start reading it. If you haven't read it, start worrying about what you're missing. It's a great book. We hand out at least 15 to 20 of them a year to clients who have situations, and almost all of them thank us. Now, page 24, what assets are creditor exempt? Let's make a list here on the left-hand side. The most exempt asset is your homestead, up to half an acre within city limits, up to 160 acres if you live in the county. If you used to live in the county and you got annexed into the city, you still have 160 acres protection, unlimited value of protection. If you have more than half an acre, you might consider carving the excess property that's not worth as much, the part that's not on the water, the part that doesn't own the house, into a separate structure that you might place under a family limited partnership or otherwise. If, for example, you have 2 acres and only half an acre is protected, the court will sell that house and only give you 25% of the proceeds. So you want to be careful with your homestead. IRAs and pensions are creditor proof, assuming that you handle them properly. 401ks are creditor proof, and of course tax deductible, so you want to maximize these. Tenancy by the entireties is also creditor protected, assuming that certain requirements are met. So if my wife Marcia and I have $1 million bank account and somebody gets a judgment against me, I can file bankruptcy and they cannot touch that tenancy by the entireties account. I'm not going to go into detail with you on how to mess up a tenancy by the entireties account. I'm just going to tell you there's 20 different ways to do it. You want to make very sure that the original account agreement was only between the husband and wife, they were married at the time, and they checked the tenancy by the entireties box. If all that didn't happen, get a lawyer to look at the situation before you conclude that it's a tenancy by the entireties account. There's just too many exceptions for me to even try to explain it properly. It's a big thing to worry about if you're not sure. 529 college savings plans are creditor protection, protected, and also a great investment if you may be paying for anyone's college. Annuity contracts are creditor protected, but can be very expensive. Proceed with caution if you're going to buy any annuity contracts or any permanent life insurance because of the costs associated therewith. Wages of the head of household, I'm going to talk about in a little while. That's a trap for the unwary. But if you support somebody else, or you're the primary means of support for somebody else, and certain other requirements are met, then your wage check may be creditor proof. And then transferring that wage check into a tenancy by the entireties account or a tenancy by the entireties family partnership or a variable annuity contract may not be considered a fraudulent transfer, even if you're in the process of being sued. A transfer from an exempt asset to another exempt asset is not a fraudulent transfer with one exception, and that's the homestead. If you sell your home, you can move the proceeds into another home. That won't be a fraudulent transfer, but our Florida Supreme Court has erroneously, but in a binding way, ruled that monies that come out of a homestead that would go into another exempt asset will not be protected if there's a claim against the client, and that would be considered a fraudulent transfer. There are possible ways around this, but you need to talk to a lawyer about it. By the way, one of my favorite sayings by F. Lee Bailey, a famous lawyer who got disbarred: anyone who does their own legal work has a fool for a client. And F. Lee Bailey is certainly proof of that, since he got disbarred listening to his own advice and doing some things that weren't so good. Nevertheless, he was a great lawyer when he was practicing, and he wrote a great book called The Defense Never Rests, which I highly recommend if you like good reading for professionals. Okay, foreign entities, foreign trusts, family limited partnerships. These are not going to be as safe as exempt assets, but they all have their places and uses, and we're going to talk about that a little bit in the 10 minutes that remain. By the way, I appreciate the questions I'm getting. I've got a question from David, a question from Susan, and I'll be answering these at the end along with any other questions, which you can type in or send me by email. I just need another 10 minutes to make up the answer. Here is the Protective Trust logistical chart. This is what most successful clients who are married want to have in their estate planning documents. A $5,430,000 trust opened for the surviving spouse that will never be subject to estate tax on the surviving spouse's death. And any excess assets can go into what we call a Q-tip trust. We really want to make sure that your life insurance and other assets on the death of a spouse can pass to a trust that can benefit the surviving spouse without being subject to estate tax in the surviving spouse's estate or claims of a future spouse. So that's a real important part of your estate planning. I don't need to go into detail, but you really need to have a lawyer who understands the tax law and who does this in order to make sure it's done correctly. Just because your brother-in-law teaches outer space law at the University of Guam doesn't mean that your estate plan was done properly by him. So you want to just be careful in that area. I'm a big proponent of term life insurance. It's very inexpensive. It provides a great replacement estate. Let's say that you're a neurosurgeon, you're afraid you might be sued, you have all your assets jointly with your spouse, maybe even in a limited partnership, but if your spouse dies, you're no longer going to have good creditor protection. You could buy a 10-year term policy for your spouse if she's a female with great health, $435 a year per million. Let's put $5 million on her. That's a little over $2,000 a year. If she dies, that $5 million goes into the protective trust that I showed you on page 25. Creditors can't touch it, and that next spouse can't touch it. So it's a great way to make sure that your creditor protection is balanced. Page 28, this is an art and not a science. Where are you going to put these assets? Don't put them in the revocable trust. Creditors can reach into the revocable trust. It's possible to draft a joint revocable trust that will qualify to be creditor protected as tenants by the entireties, but don't do that unless you really need that trust. Plaintiff lawyers are going to think it's not going to be protected. If there's any problem with the trust drafting, it's not going to be protected. So you want to be really careful. What a lot of and what I'm showing you here is the husband's revocable trust on the left, and it may be the recipient of his life insurance if he dies, but it will not own his life insurance. It will not own an annuity. It will not own his homestead. Then you have Florida tenancy by the entirety's assets. Then you have the wife's revocable trust. If the wife is not a physician, maybe it should own some assets, but if the wife gets sued, you lose the assets. Then you've got a trust for the children you can gift to every year. And then the husband could put a big chunk of assets in an irrevocable trust for the wife's health, education, and maintenance. The wife can be a beneficiary. The husband isn't a beneficiary. And that's going to be creditor-proof if it's done before there's a problem. The next tier for this, though, is this couple can also use family limited partnership or LLC planning. So, for example, their tenancy by the entirety's assets can go into a limited partnership owned mostly by them, but by part by a gift trust. So if somebody finds a way to sue both of them, or the wife dies and somebody finds a way to sue the husband, you've got the charging order protection. So that's called layered creditor protection. And on the right-hand side, if the husband is a control person, if he wants to be in control, he can set up an LLC to be owned by the trust he sets up. The LLC can be owned by the wife as trustee, but managed by the husband as as manager. So that can work out well. Page 30 simply points out that you can save a lot of estate tax money by gifting interests in limited partnerships and LLCs. Page 31 talks about our software that you can use for free if you send me an email or you send an email to estateview@gassmanpa.com. We're still developing it, but it's coming along pretty well. And these are the illustrations that it comes out with that show you that you can save a lot of estate tax if you use these various techniques. Page 41, think carefully about how your pension and IRA should be payable on death, typically to the surviving spouse for a rollover, but maybe to trust for the children. If you have a child who doesn't live in Florida, their IRA that they receive may not be creditor protected, so you have to be careful in that area. For a single doctor, the living trust does no good. You've got the Homestead, the 401k, annuity contracts, life insurance, maybe an irrevocable trust for the children or relatives or charity, owning partial interest in limited liabilities or LLCs, so you have the charging order protection. And then also you could do an asset protection trust if you want to, or a domestic asset protection trust. Nevada, Delaware, North Dakota, Alaska, other states have creditor protection laws. No one's absolutely sure how these trusts are going to work. Push has not come to shove at the appellate level, but from a negotiation standpoint, they're certainly working well. Offshore asset protection trusts work well if you set it up well in advance. The vast majority of my clients don't need one and don't have one. If you decide to get one, don't pay a fortune for it. Paying a lot of money to somebody who promises you that it will work is not as good as paying a lot less money to somebody who's realistic with you and can tell you what the pros and cons are. 529 plans have some tax flexibility pointed out on page 43. Page 44, a very popular trust. I met this morning with a couple with a $12 million net worth. Husband's going to put $5 million into a Nevada trust. Wife's going to be co-trustee with a Nevada trust company. It's going to be for the wife's health, education, and maintenance. The husband can be added back into the trust as a beneficiary if his net worth ever goes below $2 million and the trust protectors decide to do that. So the husband has the possibility of getting the trust back if he ever needs it, but it's out of his estate. Creditors should not be able to touch it, and it should save this couple conservatively $5 to $10 million in estate tax based upon some other things that we're going to do with the trust using conventional methods of planning. Page 45, don't do that strategy at home either or with a non-specialist lawyer. There's a lot of considerations. If you've already set up one of these trusts, it may not have been done correctly. You might want to read through pages 45 and 46 with your advisor. Page 47 talks about offshore trusts, domestic trusts, and selection of jurisdictions. There's more here than I can cover. I just decided to leave it in here so that you could see what we tell our more advanced seminar attendees when we speak to lawyers, CPAs, etc. By the way, everyone who started with us is still here. Thanks very much. Page 53, that same trust with $5 million could own a limited partnership interest and the husband can manage it. So a lot of good stuff here. Page 54, you can set up multiple partnerships, LLCs, and trusts, and none of them have to file a tax return. Sometimes the CPAs think there have to be a lot of different tax returns, but that's not the case. You can design most of these instruments so that they don't need separate tax returns, and that includes tenancy by the entities in Florida, in my opinion, and we have supporting documentation for that if you'd like to see it. Some clients have investment houses. They'd like to put them in an LLC, but the insurance rates go up significantly. You can do the equivalent with a Florida irrevocable trust that can be creditor protected both for the contributor and protect you from liability associated with the rental house. So don't forget the limited liability trust. Here's a trust you can set up for your child who goes to college to get the best tax results for that. And now I'm going to talk just for 2 minutes, since I only have one left, on protecting the medical practice. I'm sorry I only left myself a couple minutes here. But basically, don't think that medical entities have to be owned only by the doctor. Most of them can be owned by the doctor and spouse as tenants by the entirety. So if the doctor is in a car wreck or has something like that happen, the entity can be protected. That also goes for the entities that own the real estate. Now, put the car in a separate LLC. Don't have the car in the medical practice entity if you want to protect your accounts receivable, furniture, and equipment. And then have your building and equipment in separate LLCs. You can separate them using some separation techniques. If they're all stuck in the same company right now, I went to page 67 to show you the new parent F reorganization technique, where you can divide assets within a medical practice into separate subsidiary entities without changing the tax ID number of the medical practice or the S corporation status using what we call the new parent F reorganization. Don't leave home without that. Also, in the medical practice, think about chart 65 here. The clients borrow money from a bank. They give the bank a mortgage on their building that's inside of a building LLC owned by their spouses. The bank takes as additional collateral the furniture, equipment, and accounts receivable of the medical practice. Also, the medical practice signs a 20-year lease with the building entity saying that if it ever goes insolvent, if it ever becomes insolvent, then it owes 20 years of rent. This will serve as a deterrent to plaintiffs who look at a medical practice. There's other things you can do for the medical practice entity, but at least get this done. None of this is foolproof, but all of this we have found helps immensely in the event of a creditor situation. There's more complicated things that can be done. You can peruse this at your leisure. There's some checklists at pages 68 and 69 and 70. I think you're going to find that they are all self-explanatory. And now that ends the seminar, but let me ask some of the questions. So David says, what about protection extended to proceeds paid out of an annuity or a life policy if they're held separately and not commingled with other personal assets upon receipt? There are court cases which say that if you take money out of an annuity or a life policy and put it in a bank account in the name of the doctor, it's creditor protected. But you know what? I'm not going to rely on that. I think a plaintiff lawyer will go bananas seeing that there's money in the doctor's name. I don't know how high those cases were appealed, but it's a good point, David, and I appreciate that and all the other things you've taught me this week. Another question from David, what are the implications for practitioners who fail to provide credible and meaningful guidance regarding the use of exempt assets because the attorney did not understand the asset? You're right, the attorney gets sued for malpractice. So if you're an attorney giving this erroneous advice, either refer the clients to a lawyer who knows what they're doing and go see another lawyer who knows what they're doing to protect your assets. I say that tongue-in-cheek. Hi, Susan. Thanks for your questions. You had a client, please do everything you can to settle within policy limits. You wrote that letter to the carrier, and the financial advisor recommended an attorney. Susan's concerned the client may eventually have a problem. Please discuss and advise. Well, I very, very often, representing physicians, will call the defense lawyer. Say, hey, Clyde, what do you think about this case that the insurance carrier is paying you to defend? Clyde says, you know, hopefully it can be settled within policy limits. Don't tell the carrier I said this, but would you mind calling the plaintiff lawyer, asking them to settle within policy limits, and then writing the demand letter? I'll feel a lot better if you do that, but I don't feel comfortable doing it myself because I want this insurance carrier to continue to hire me to cover claims. So you do want to get an independent lawyer active anytime there's a malpractice case, at least to ask the defendant lawyer if they get along with the plaintiff lawyer, what they think about it. Is the carrier paying for the right experts? What's going on here? A lot of times the defense lawyer will tell me things that they don't feel so comfortable telling my clients. A lot of my clients are lifelong friends, and then I can help the situation out. Okay, the one promise I broke was that this was supposed to be a 30-minute webinar. It went 34 minutes. I guess that's about 8/10 of a billable hour. I hope you enjoyed this webinar. I hope you got some ideas out of it. I hope that you feel free to ask me any questions and to point out any improvements we can make. If you'd like a longer version of this, we'd be glad to do it. Have a fantastic day, and may the rest of your hours be billable if you're a lawyer or a CPA, or productive if you're a doctor or other professional. Thank you very much.